48. Give it a second, counsel. Let's just let everyone settle down for those who are leaving. Okay, counsel. Do you want any rebuttal time?
Just please, Your Honor, 5 minutes.
5 minutes. Go ahead.
Thank you. May it please the Court, my name is Peter Sherwin of Proskauer, and I'm counsel to appellant petitioner H.M. This is a child support proceeding, and family court clearly has subject matter jurisdiction over child support proceedings. A different decision is not dictated simply because respondent is a woman.
Which article do you say gives them jurisdiction?
I say the Constitution, Article 6, Section 13b-4. I also would cite you to Family Court Act.
I've phrased the question poorly. Is this an Article 4 or an Article 5 case?
It is an Article 4 and 5 case, Your Honor.
But
Article
support is under 4.
Support is under 4, but under Article 5 as well, in Section 561,
Parentage.
it directs that a mother can be ordered to supply child support pursuant to Article 4 as well. So it appears in both
Let's
articles.
take 5 first. How would you interpret 5 in relation to gender-neutral language or the lack thereof?
How would I do that? I would say you should do it the exact same way you did it in Rebecca G. in connection with 514. 514 indicated that only the father had the obligation to pay for the medical expenses of the mother being pregnant. And in Rebecca G., you acknowledged that that had to be read gender neutrally, otherwise it would be given an unconstitutional
Why is it
reason.
necessary for you to ask us to go through this exercise?
It's not. I don't need to go there.
It's not. So you have a complete remedy under Article 4.
Well, first of all, Your Honor, we're here on subject matter jurisdiction.
Okay.
And we
Okay.
only
Okay. I phrased it badly again. You have all the jurisdiction you need under Article 4.
I have all the jurisdiction I need under Article 4
So
and the Constitution.
why should we go through this exercise of saying man means man or woman, father means parent, male means male or female? What's wrong? Why don't we just go to Article 4 and save the trouble?
I'd be fine with that, Your Honor. Unless you come out as the appellate division did and ignore that whole argument, that whole series of argument, and go through the tortured, convoluted way of looking at UIFSA and its use of parentage and say that nonetheless we're going to be
Is UIFSA
constrained.
really important here?
It's an additional argument,
I mean,
Your Honor.
would anyone really say that this child has more rights than a child in New York?
We're not talking about more rights, Your Honor. At most, what UIFSA did is say that parentage determinations of a woman or anyone always have to be in family court.
Is parentage assumed in the support section?
Is parentage assumed? In Article 4, it basically is, Your Honor. I mean, you start out your claim under 413, and you say the respondent is the parent and owes these obligations. And then there's a determination of whether or not the respondent owes child support. And as the Court recognized in 1994 in Re Baby C, that's a determination that's binding for the purposes of child support. And it's not necessarily a determination for all purposes.
But let me once again rephrase a question I asked before. Are you saying that this child, is there any plausible argument that the result is different in this case depending on whether we have a child in Canada or a child in New York?
It is possible, if you ignore the constitutional provision and if you ignore the jurisdictional provisions in Family Court Act 115 and 411, and only look to under UIFSA, there is a difference between whether it's UIFSA or domestic. This case, ignoring all those other arguments, arguably could be only in Supreme Court.
Do I detect a certain lack of enthusiasm for that argument, as you stated?
I don't think you need to get to it. This is a simple case. It is truly a simple case. It's a child support proceeding, and the Constitution and 115 and 411 give family court jurisdiction.
Can we really address this without addressing the substantive question of whether your client, the opposing party to you is a parent or not? I mean, if she's not a parent, aren't we wasting our breath here?
The question of whether or not she can be a parent is not at issue in this appeal. It's not even contested by the other side. They just say we haven't properly alleged the reliance element, but they don't ever argue, and nobody did, even the appellate division majority, didn't argue that respondent is incapable of being a parent under New York law.
So you take it as common ground that she could at least be found to be a parent?
Yes.
If that were wrong, and I seem to remember somebody in the previous argument might have thought it was wrong. If that were wrong, then all this talk about jurisdiction becomes totally academic. I mean, you don't need jurisdiction because you have no claim, right?
No, Your Honor. Let's unbundle it a little bit. It is well established in New York that determinations in family court, courts of limited jurisdiction, of whether or not a person is a parent for the purposes of child support, and also in the ancillary situation if a person is married for spousal support, is limited to that context. And that's all that's presented
I think
here.
I'm asking a different question. Assume, hypothetically, that we were to hold as a matter of law that if you've got one parent who's your mother, the only way you can get another female parent is by adoption. Forget about everything else. If that is the law, then this whole case ceases to exist. I mean, that seems self-evident, right?
You would be overturning
Okay,
decades
it'd be a
and
very
decades
bad thing.
of
But
cases finding where a non-biological, non-adoptive person can be responsible for child support. Decades.
Okay, but even if we were so benighted as to do that, that would indeed end the case.
No, I don't believe so, because
Why
then you would have the constitutionality problem that you wanted to avoid earlier. Because then you would be saying that merely based upon the gender of the respondent.
I get the sense that you're really still refusing to accept my hypothetical. Just suppose we actually thought it was the valid law of New York that his client couldn't be a parent. I guess I'm just saying it's self-evident. If we were so foolish as to think it was constitutional, it was statutory, that his client can't be the parent, then obviously there is no support case, right? I know how much you resist the hypothetical.
I don't know, because let me cite In Re Baby C again. In that case, this Court found that a person could be a parent through equitable estoppel, for all purposes, equitable adoption. And then part of that case, you also acknowledged, even though the facts didn't get you to that point, you acknowledged that setting that aside, the respondent could still be on the hook for child support. So even if, under your hypothetical, Judge Smith, if this Court determined that for all purposes E.T. could not be this child's parent, there would still exist under In Re Baby C the concept of going after her for child support. And the reason for that is child support focuses almost entirely on the best interests of the child. And historically, and always before Shondell came and expanded the concept of equitable estoppel in the child support context, you looked at who caused this child to be brought into existence, who caused this child to be brought into the house, who caused this child to be moved from the situation that they otherwise had.
Let's say we agree with you and we say that there's just an obligation for support. What about custody and visitation? Does that follow, or is that separate?
It's separate, Your Honor. It doesn't necessarily follow.
And your client's not seeking that. Your client has just brought a support petition in Canada.
Correct. And E.T. is not seeking custody or
Well,
visitation.
whether or not it's being sought, you're saying it can't be sought.
No, sorry, Your Honor. I didn't mean to say it cannot be sought. What I'm saying is that the determination that E.T. is a child support parent in family court under this petition does not necessarily give her the right to child support and visitation. It doesn't necessarily
Is there any type of latches argument that applies here?
There could very well be, Your Honor. There could be. There could be judicial estoppel.
We've got, 12 years here that's
Oh, I'm sorry. I thought you were
expired?
talking about the question of whether or not E.T. could seek custody or visitation if she's found to be a child support parent. The issue as to whether or not there's estoppel here, first of all, New York law is clear that you have a child support obligation until the child is 21. All right? And it's also clear that the support obligation only goes back until when the petition is filed. So we're only looking for support back to when the petition was filed, November 15, 2006. The question of whether or not there's been laches or estoppel or a length of time doesn't apply. And again, it's because best interest
Well,
of the child
it
governs.
seems to me a little bit different, though, where someone knows they're a parent and is not performing parental duties or providing financial support, and perhaps in a situation where someone doesn't view themselves as a parent,
Well, in this situation,
and
Your
then all of
Honor,
a sudden, years later, is told you owe child support.
and then those facts certainly can be brought to the attention of the family court judge. And the family court judge, as part of the equitable estoppel doctrine, can find, no, I'm not going to equitably estop this person. But here, in our case, the petition alleges not only that E.T. provided some financial support post-abandonment, but also that H.M., on behalf of the child, baby R, sought child support from E.T. E.T. agreed to provide child support conditioned upon reconciliation of the two adults. That didn't happen. And also it's alleged in the petition that H.M. was unaware of her right to seek child support from E.T. She's in Canada. She's Canadian. She was unaware. When she became aware, she did bring the proceeding.
Would this apply to grandparents or cousins or anyone who decides that because somebody's a little bit down on their luck, they're going to send them $50 a week, and after a while they stop? Can you sue them and say you've become responsible for the child support?
No, it would not, Your Honor.
What would the distinction be
The
then?
distinction is E.T. held herself out as a parent and is part of the conception agreement
So
and the decision.
it's not simply you're not seeking a determination that she's an individual responsible for the support of the child. You're seeking a determination that she's a parent.
For the purposes of child support, exactly, Your
Well, I
Honor.
used, if she dies, does E.T. inherit? I mean, if E.T. dies, does the child inherit?
I don't know 100% the answer, but I think actually not. Because in order for that to happen, E.T. would need to bring a plenary parentage determination.
If the child is involved in an activity that parents are responsible for, the intentional acts of your child under the age of 16, is she responsible?
I don't know if she is, Your Honor. We're here talking about the financial responsibility of helping to support a child that you caused to be brought into existence.
So I go back to my grandparent and my cousin. I mean, isn't that exactly what you're talking about there?
Then I should have answered in addition, Your Honor, in the context of holding yourself as a parent.
For
And that's
example, a
what's alleged here.
situation where a parent may have a teenage child who becomes pregnant. All right.
Yes.
The child's not going to get married, but the child's going to have the baby and is going to live in the same home with her mother. And the mother has assumed responsibility to educate this child, to support this child, et cetera. That's your question.
But under no circumstance has the grandmother in that situation ever held herself out to be a parent, nor did she say to her daughter, I agree that you should get inseminated or you should become pregnant, and I will be a parent.
But she's assumed all the responsibilities to
You seem to be
educate.
threading the
That
needle.
wouldn't be a child support claim under Article
But
4,
that
Your
could
Honor. It
happen
may
with-
be a contractual claim.
I mean, that
but it
could
wouldn't be
happen.
child
Exactly what you described could happen with a grandparent, couldn't it?
And there could be a
I mean,
estoppel.
yes, go ahead, get pregnant. Don't worry about it. I will play the role of a second mother to this child. I could imagine a grandparent saying that to a parent. Does that do it? Does that put him within family? Does that make her a child support parent?
No,
Why not?
because they never held themselves out to be a parent.
It's the responsibilities of the parent, not a parent? that
Exactly
the
right.
distinction?
They created this relationship and they agreed to create this child as each would be a parent.
Let's
I'm not saying that the grandmother.
let's make it a father and daughter and granddaughter. And the father says to the daughter, "I understand you're a single woman. Go ahead and have a baby. I'll be a father to the baby." And he holds him and he acts exactly like a father. He tells everybody, "I'm this child's dad." Is he on the hook for child support?
I have a hard time seeing that scenario, Your Honor, and I don't honestly know the answer. But yes, if the other person holds themselves out
I mean,
to actually
he
be
doesn't
the
pretend
parent
to
of
a
this child.
biological relationship. He just says, "I feel myself to be this child's father." Surely, I think grandparents must do that often.
Are you making the
My grandparents don't, Your Honor.
Are you making the distinction between holding yourself out to have the responsibilities of a parent as opposed to holding yourself out to actually be the parent? Is that the distinction that you're making
And it's
in
even
answer to the
broader than that.
hypotheticals?
On the one hand, somebody can say, look, you go to law school, I'll pay for law school. The person then goes off to law school and clears huge amounts of debt, and then the parent or whomever reneges on that obligation. There may or may not be a breach of contract claim there. That is worlds apart from the situation where somebody actually causes someone else to bring a child into
I
existence.
hate to ask you this question because it might beg a bright line, but where do you draw the line as to what constitutes the support parent that you're suggesting? How much? How little?
Oh, my goodness. Well, that's something that's been developed over many, many decades in New York Supreme State Court practice. The line comes lots of different places. The line was drawn long ago in our situation to include it. I mean, that's Gursky case, that's Karen T. All the time. I mean, that's fundamental. When you decided Shondell and allowed child support obligations in the context of no agreement to bring a child into existence, no agreement to adopt a child when they come into the home, but rather based upon a post-existence emotional bond. You really expanded the law.
I think we said in the last one, they're a little unique. You know, the scenario where I want to divorce him, by the way, you're not the father, and then the father decides, well, I'm not supporting a little person. We say, yes, you are. I mean, for all of the reasons that you just delineated. But in this situation, I'm wondering, you know, how many of the bricks do we have to put on which side of the scale to say this turns into a support parent as opposed to, you know?
You don't need to decide that on this case. It's a simple subject matter jurisdiction case.
I see. That's right. You're so.
Okay, counsel.
Thank you.
Thanks. Counsel?
Good afternoon, Your Honor. May it please the Court. I'm David Tennant, and I'm representing obviously E.T. in this proceeding.
Why shouldn't we interpret the statute the way the dissent in this case below interpreted?
In terms of the
Way Judge
Uniform Act?
Balkin, yeah, the way Judge Balkin interpreted the statute.
The Uniform Act.
Yes.
The Uniform Act is by its name, uniform, generated by a law commission process, intended by its own legislative history to basically be a way to facilitate child support and marital support proceedings across state lines, critically without changing the substantive law of any state. I mean, that's what a Uniform Act.
So this result would be different if we were in a state that allowed same-sex couples to marry and to have children, et cetera. The result would be different then.
That's correct, Your Honor.
So if we were in Massachusetts, for example, across the border, we'd have a different result here.
Very true. It's dependent upon the substantive law of each state that adopts the uniform law.
Well, why can't we, according to our substantive law, why couldn't we, as Judge Saparik says, why couldn't we interpret Article 5 and Article 4 the way Judge Fisher and Judge Balkin interpreted it? What's wrong with their view of the Family Court Act?
Let me address them in turn. Article
Yeah,
5.
good.
Obviously, that is a paternity statute.
Yeah, but aren't there parts of Article 5 where they do, you know, use kind of gender-neutral?
The gender-neutral provisions in Article 5 are limited to articulating the general proposition that both a man and a woman have support obligations. That it's not doing anything more than saying a woman can be held to the same legal standard of providing support for her child that a man can. The particular provisions that are at issue here in determining who is a parent, I mean, that's the critical question. Who is a parent? And that
But in today's society, why couldn't you have maternity, in effect, as opposed to paternity, interpreting that language more broadly?
Parentage.
Parentage, yeah.
Oh.
I'm sorry.
I think the beginning point is looking at legislative intent and the language that the legislature actually uses, and there isn't anything ambiguous about saying that the male party who's before the court in an Article 5 paternity proceeding whether that male party is going to be determined to be the father of the child. That is a specific mandate from the legislature to have it a male-specific process in light of the biological question.
Your adversary says he doesn't need Article 5, that Article 4 covers it. Why is he wrong?
Article 4 is a support proceeding that doesn't answer the question of whether it doesn't set up the process by which somebody is designated a support parent. I mean, that's not found anywhere.
Oh, wait, suppose, I mean, a mother can be sued for support under Article 4, right?
Correct.
And suppose that an alleged mother is sued for support under Article 4, and she says, no, not my kid, it's my sister's kid. Does the family court not have jurisdiction to resolve that question?
For the kind of historical, factual question of who actually had this child come out of their womb, sure.
Okay. What about suppose she said, it's not my kid because I signed a valid surrender? Can the family court decide that?
If there is
question
actually
of law.
a legal document that's a yes-no inquiry as to this mother's status.
Well, ultimately, whether your client is a parent is going to be a yes-no question, too. There may be a lot of complexities before you get there, but it's got to be yes or no. Why can't the family court answer that under Article 4?
It can answer under Article 4 whether the mother signed a document that actually relinquished parental rights, terminated the rights.
But can it answer the question of whether she engaged in conduct that subjected her to a support obligation?
And that's where we take the position that it's fundamentally different if you're talking about a broad inquiry, like in Shondell, where you're looking at
So there's a difference between, there's a jurisdictional difference between broad inquiries and narrow inquiries?
Absolutely, because it's dealing with whether this is, in its fundamental nature, a request for equitable relief to actually have a determination for the family court to balance out of principles of fairness all kinds of factors.
Bottom line, are you saying this should be in Supreme Court and not family court?
Correct, Your Honor.
Can we transfer it?
Yes, Your Honor.
Why isn't family court better suited to determine these kinds of issues? By design, by statutory design, why isn't it?
Well, the reason, we're not talking about the kind of, could the legislature decide in its wisdom that this should be within the jurisdiction of family court and to expand family court's jurisdiction to allow these proceedings to be there? That would be a legislative function. What we're saying...
Family court can find support and can find estoppel, right?
The estoppel principle that's available in family court is specifically, it's in Article 4 and Article 5, and it's specifically embedded within the provision. It's 418A in Article 4 and 532 in Article 5. And it's specifically embedded in those provisions that deal with genetic marker and DNA testing. And if you, Shondell makes clear, as do other cases, that the way in which that statutory remedy is planted into the DNA genetic marker testing section is because you want to figure out if it's in the best interest of the child, where there is biological doubt about who the father is of this child, which is the whole premise for having a paternity proceeding, to have the court undertake a separate inquiry as to whether to go forward with those scientific tests or, in light of the factors...
Has science changed? Would it make sense to sort of bring the statute in tune with modern technology, to interpret it in a way that better reflects modern technology?
Your Honor...
Medicine, whatever.
No, Your Honor, I think, I mean, the statute was amended in 1990 to introduce the concepts of genetic marker testing and DNA testing. And I don't think, those are still the kind of day in and day out tests that are used to rule in or rule out the possibility that a particular male is the actual biological father of a particular child.
Is your adversary right that you don't say in this that there's no way your client could ever be found liable for child support? You say that we don't have that. I assume you say ultimately she's not liable, but you say that you're willing to assume for purpose of the argument that she could be. You just said it should be Supreme Court, not family court, that decides it?
That's correct, Your Honor.
So what would happen? Would they have to start a whole new proceeding, or could you answer Judge Graffio earlier that we could transfer it? Do we have the authority to transfer this USIFA, is that the way you pronounce it, UIFSA proceeding to Supreme Court?
Well, I think as an initial determination, is this really a proceeding within the terms of the Uniform Act? If it's actually outside of the family court's jurisdiction, which is our
They're
premise.
gender neutral. They talk about parentage. The UIFSA talks in terms of parentage, not in terms of paternity.
Correct.
Right?
Right. And that's dealing with, as we talked before, about a Uniform Act that is intended to basically be adopted by the individual states
Right.
based upon their substantive law. So our position is that that use of parentage doesn't change the substantive law of New York.
Can I ask you how that works? If the petitioner's in Canada and they recognize same-sex marriage, but under the Uniform Act, I mean, the petition is filed in Canada and it comes down to here, and our state says we don't recognize same-sex marriage, our law applies on that?
Right.
So if the respondent then were to move to a same-sex state, and the same petition would be granted?
Could be. I mean, the law is the law is the law, and we're looking at, New York has its body of law that is very specific as to the rights and remedies under Article 4 and Article 5, and the kind of overarching equitable inquiry that we're looking at here in terms of the claim that HM is seeking to have adjudicated.
Well, that's that unjust discriminatory result that Judge Balkin was talking about in her dissent, correct?
Well, there actually isn't any constitutional issue here. I mean, it wasn't raised below, and there was an argument by appellants that it wasn't necessary to raise any type of constitutional challenge here because the first reading of the New York statutes that would render any type of discrimination didn't occur until the appellate division decided the case as it did. That's actually not true. At the outset, the support magistrate read the case, the jurisdictional question exactly as the appellate division majority did, and certainly from the outset, if there was a constitutional challenge to be brought here, it should have been raised, should have been argued. The dissent in the appellate division was in a position to articulate an equal protection framework, and they didn't.
You don't need to go to the constitutional argument to find in favor of your adversary, right? We don't have to go on constitutional grounds.
In terms of statutory interpretation, right? I mean,
Right. I mean,
this Court could read
Exactly.
Article 4 and Article 5 and not go to a constitutional analysis, and certainly that's within the jurisprudence of the Court. You try not to get to a constitutional inquiry. Here, of course, we take the position that Article 4 and Article 5 can't be read that way, and that what HM is really...
If we were to agree with you, I'm not sure I'm clear on whether the Uniform Act applies in Supreme Court. Can it be applied in Supreme Court?
Well,
would she still have representation under the Act in Supreme Court?
I think, because this is uncharted territory, that what you would have is a determination that the claim that HM is seeking to bring in family court, if it's deemed to be an equitable claim outside the limited jurisdiction of family court, then it's also outside of the Uniform Act and can be transferred to Supreme Court, a court of general jurisdiction with plenary equity power, and there wouldn't be any issue at all in terms of whether this is conflicting with the Uniform Act or has to be transferred back.
So is that a yes or a no? It's
in terms of
the Uniform Act could proceed in Supreme Court? I'm still trying to understand your answer.
Right.
Yes or no?
I think the Uniform Act could proceed, if it were deemed to be under the Uniform Act, it could proceed in Supreme Court.
Well, in situations, in matrimonials, for example, where there's a support obligation, it can be enforced through the Uniform Act in Supreme Court, who has determined what the support obligation is. So I don't see why couldn't
Well, if
do
I
that.
understand your argument, what you're saying is, I think under all these uniform rules, our Article 5B is our connector. So to get to us, you got to get to Article 5B. At that point, you're standing there saying, you don't have the jurisdiction to hear this. Someone would have to move it to Supreme Court, right?
Correct.
That,
And we don't see a procedural or jurisdictional bar to the matter being transferred from family court to Supreme Court, whether it's under the Uniform Act or outside the Uniform Act.
I mean, that's just buying time, though. I mean, the family court, your argument is the family court can't make the determination that has to be made here, and it would have to go up to the Supreme Court, who then could make it, and I assume would then refer it back to family court to make the uniform ruling? Or would they just, I guess they have general jurisdiction.
It would remain in Supreme Court that is actually charged with making the kinds of determinations that HM is seeking, namely an implied contract and equitable
Okay,
estoppel.
once they've made that determination and they make it in HM's favor, then you stay in Supreme Court and have a good old-fashioned support trial, the same you would have in family court?
Sure.
Supreme Court does that every day in matrimonial actions.
Right.
Okay. Anybody else? Okay, counsel. Anything else you want to add?
No, thank you.
Okay, thank you, counsel. Counsel, rebuttal?
Yeah, if I may talk.
The reason that I've asked all these questions is that all our assisted reproductive cases have occurred in Supreme Court.
I don't know if
Like
that's.
Perry Rogers, I mean, cases of that nature have all been heard in Supreme Court.
Well, Karen T. was in family court, Monroe County Family Court, and that one actually dealt with
I'm
determination of a
talking about
woman.
our cases.
I'm sorry,
in
Your
this-
Honor.
In this court.
Um,
Cases that we've either affirmed, that we've issued decisions on.
I don't think there's
that
any
involve
dispute
Supreme
that,
Court.
even under the definition of family court's exclusive original jurisdiction, that Supreme Court, at the end of the day, always has residual original jurisdiction.
No, but it seems to me we're kind of torturing Article 5. I mean, Article 5 is based on biological factors. It's all based on genetic testing. So we're trying
points, Your Honor.
it somewhat looks like we're taking a round peg and putting it in a square hole or vice
Not
versa.
at all. You're doing exactly what the courts have been doing, family courts have been doing ever since 1935. And the example is in Letts. In Letts, the question was whether or not, in a child support proceeding, whether or not the respondent, a man, was considered a father. All right? And that was before there was any statutory ability to determine parentage in family court. And there, the First Department held in 1935 that, yes, family court has the ancillary jurisdiction to decide that element of the child support claim. This court actually did the exact same thing in Loomis in 1942. There it was spousal support. And again, family court, limited jurisdiction. And there, the woman alleged that the husband, that there was a valid marriage. He countered and said, no, we got a divorce abroad. The court, in 1942 in Loomis, said family court has the ancillary jurisdiction to determine the validity of that marriage for spousal support purposes. Not for anything else, but definitely for that. In neither of those situations, because that issue was there, the validity of the marriage or the existence of paternity, both of which were non-statutory at the time, neither of those resulted in the case having to go to Supreme Court. And let's also understand why they're fighting so heavily to get this to Supreme Court. The reason is, while the appeal was pending in the Second Department, we got a support order. Justice Warren found that she's equitably estopped. We have an order that says she has to pay $800-some a month and has to pay tens of thousands of dollars in arrearage, and they want to have a do-over. That is not in the best interest of the child. This case has been going on since 2006. And let's take it back to UIFSA. The reason that UIFSA exists, the reason that the federal Congress mandated that every state be active, was so that child support proceedings in the interstate context could weave fast, and to avoid the exact jurisdictional problem that we've got right here. And so back to Judge Smith's question, I don't think UIFSA created new causes of action and rights. But UIFSA definitely put in family court jurisdiction over all interstate UIFSA proceedings. And that's because in UIFSA Section 102, it designates family court as the sole UIFSA tribunal.
Do you say that it gave jurisdiction over cases whose counterparts would not be in family court if there were no foreign party?
Correct, Your Honor, and that's
But
because...
what case is that? It has to go to family. If it were a New Yorker, it would go to Supreme Court. But if it's a Canadian, it goes to family court.
I'm sorry, there is no case. It's UIFSA 1997. It was enacted in Article 102.
But I mean, what hypothetical case would that apply to?
Well, let's say both parties, this exact situation.
How could you have a foreign petitioner that has more rights than an in-state petitioner?
It's not more rights. It's which court are you going to place this in? Which court is going to hear it? And there's nothing that says that the New York legislature couldn't...
The federal statute can't change the New York court's jurisdiction.
I'm sorry, Your Honor?
The Uniform Act can't change the extent of New York court's
The
jurisdiction.
legislature across the street enacted it, and they did it. And they changed jurisdiction when they enacted it.
So I'm still looking for the case. You're going to give me a hypothetical case in which a New Yorker would have to go to Supreme Court, but a Canadian can go to family court?
All of this is premised, it would be our case, Your Honor, premised on you finding that ancillary jurisdiction does not exist any longer in New York. It is, as I said earlier, a secondary argument.
You say the case doesn't exist, but if you lose on what you call ancillary jurisdiction, are we talking about the Article 4 jurisdiction?
Exactly, Your Honor.
Okay. But so that you say it doesn't exist, but it would exist if you lost. It would exist if you needed it to win the case.
Thank you, Your Honor.
Okay, thank you, counsel. Thank you both.